December 3rd, 2024, officers were dispatched to the HEB located at 4955 State Highway 6 regarding a disturbance in progress. Officers received 4 calls, all from witnesses who stated the defendant was arguing with and assaulting.
10 cases in 2 years, weapons charges, assault allegations, marijuana, felony probation, and now, a brand new arrest that could trigger everything. What starts as a routine probable cause hearing quickly spirals into a constitutional showdown over what interference actually means. Did this defendant actively resist arrest, or is this a case of overcharging? And when the judge says, "Let's watch the video," the entire courtroom dynamic shifts. Because in modern courtrooms, paperwork tells one story, but bodycam footage can tell another. And today, that difference might decide everything.
A female. While en route to the location, officers observed the couple at the intersection about 0.1 miles away from the HEB where the original call was
Observed what?
located. They saw the couple at the intersection.
Okay, they saw. Okay.
Yes, Judge. The defendant was uncooperative with officers. The defendant advised he and the complainant were involved in a verbal altercation and stated he threatened her, saying he would slap her. When officers advised the defendant that he was in custody for an outstanding warrant, he got upset and began to yell. Officers located a clear plastic bag containing 3.6 grams of marijuana. The defendant refused to comply with officers' commands to sit down and would not place his legs and feet inside the vehicle. The defendant pushed back against the officer's hand with his chest when he attempted to help him into the vehicle, pushed his legs straight and applied force toward officer's hand in an attempt to stop him from placing his legs inside the vehicle, and then used the bottom of his foot against the bottom of the door frame to further resist. The defendant refused to speak with officers and would not cooperate with the investigation. All witnesses on scene heard the defendant threaten to hit CW, and another witness stated she observed the defendant push the complainant in the chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County Sheriff's Office for aggravated assault with a deadly weapon.
But he has an open ag assault somewhere else too?
In Fort Bend County, Judge.
My understanding is it's
And
an
it was
older
open
case.
warrant at that time?
Yes, Judge.
May I respond to all this, Your Honor?
Sure. Please.
Where's the interference? Okay.
Well, they're putting him in a car and he's like going blank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done, is it a resisting? Maybe, but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them. And they're a 0.1 mile away from the location. For what?
Well, okay, I get that, but so we've got a disturbance at HEB. Cops go there.
Okay.
They start to talk to him, and I guess at that point says, "Hey, man, I'm going to slap her." So at that point, I mean, that's what we have.
Okay.
Right? Mr. Zenon, there's always 2 sides to the story. I get it. This is just probable cause. It doesn't mean that you're guilty of this offense. It's just probable cause. That, in and of itself, is it enough to continue an investigation? And it is, because it's a potential terroristic threat, right? So they have enough to go forward to investigate. They start investigating, and then they find that you have a felony open warrant. And then they find there was something else was there another warrant that you said?
No, it's the aggravated assault. But Judge, I also would like to point out that
But they end up putting him in the car. And at that point, he basically just goes blank like this, for them being unable to effectuate an arrest.
And Judge,
I don't think that's an interference.
I don't. I mean, I think the intent of the law within itself is that if you're interfering with their investigation for something else. He did not interfere with anything.
Hold on, let's read the code. Let's read it, because I mean, there's no better way. Let's read it.
Hold on.
I'll give you. All right. Let's pull up the code.
Intake could have taken some other things, but
Well, certainly they could have taken a whole myriad of. I mean, you're lucky they didn't charge you with assault of a peace officer. There's a whole host of other charges that they could have put on. You know,
but they didn't hit. They took the one that I do not believe applies here.
let's read the code.
Okay.
Let's see what the code says, because there's multiple ways that a charge can, that you can charge someone with facts, right? There's multiple ways that can It's 3815.
That's okay. Don't worry.
You're right. It could have been like a resisting, you know, but. Okay, you ready? A person commits an offense if the person with criminal
This is a legal turning point. The statute says a person commits an offense if they interrupt, disrupt, impede, or otherwise interfere with a peace officer performing a duty. That language is intentionally broad. Prosecutors like it because it gives flexibility. Defense attorneys hate it because it can feel limitless. Now remember, this isn't trial. This is probable cause. The burden here is extremely low. The judge isn't deciding guilt beyond a reasonable doubt. She's only deciding whether there's enough to move forward. But here's the real tension. If interference can mean almost anything, where does it stop? Is refusing to move your legs enough? Is going plank in the patrol car enough? Or does it require active, intentional obstruction? Drop it in the comments. Where would you draw the line?
That were made about this couple arguing.
Mhm.
I mean, that's what they were investigating.
And the witnesses all described.
They put
the
him, I guess,
defendant.
did they put him under arrest at the time when he said that he was making that threat?
And with being
I mean,
point
did
one
they
one-
have the authority to arrest at that time? Right?
So I think it was during their investigation, the defendant admitted to threatening, that he would slap Miss Clark.
And it's at that point they start to put him under
At
arrest?
that point, they ran him through the NCIC and they found that there was an active warrant, and then they informed him that he was in custody.
Okay, then that's a resisting from what they're using to say he's pushing back or
But
pushing.
remember,
That's
I
a
mean,
resist.
it-
That's not
it
interference
could
with
be-
public duties.
But it could be that a set of facts can be multiple charges, right? So it could be resisting, but it could also theoretically be interfering with what he's trying to effectuate, which is an arrest. It's a duty that he's performing. He's performing the duty of an arrest.
But again, it's vague. It's if the officer didn't put in the report. He's not saying in the dim summary, you are under arrest.
We don't.
Well, I mean, it's.
Okay, well, I mean, but so
I mean,
this
we
is-
don't know. I mean,
Okay, I'm just saying.
both he says he's under arrest, but I mean, damn, it's all but clear.
I mean, this is.
We also
And
don't
he's-
have the offense report
We
yet.
don't
Judge.
I don't
Because
care. I
he
mean,
was in
but
the
I think that
process-
there's enough, he's under, he places him in custody, right? He's going to arrest him, starts putting him in the car, and dude goes plank.
Oh, I see. I know, but I don't have the video.
I've
I mean, I
shared the
think that-
videos with.
Remember-
You're right, I haven't had a chance.
Guys, this is a very low burden. This is probable cause. This is not beyond a reasonable doubt, you know? Beyond a reasonable doubt is a different standard. This is just to see if there's enough to go forward. And according to this, you're disrupting, allegedly, you're impeding, and you're otherwise interfering with him trying to arrest you and putting you in the car. A person can interfere with duties in multiple ways. It's not just one way. Like you go over there and someone else tries to stop an arrest from happening. I don't know. I think that there's enough.
Whisper to me because I want to know what you're about to say.
And if you want time, you guys can go back and talk.
Okay, well, I got to say.
Required 3 times to search me.
Can I have a moment to look at the video here? He's telling me a whole separate fact pattern.
But I need to give them time to be able to look at it too. I mean, it's noon. Why don't we do this? Why don't we roll it to Monday and we can, I'll find it now. We can reapproach Monday morning or tomorrow even. And if you find,
I mean, because
if you find a completely set of different facts than to what they're saying on video, I'm all ears. I'm always all ears. I'm always willing to rehear probable cause at any time. I mean, it's not the be all end all. But for now, what they're telling me, if it in fact is the case, there's enough for probable cause to go forward. Is there enough beyond a reasonable doubt? I don't know. But be that as it may, you know. Okay, it looks like they didn't give him a PR bond on this.
Okay, so well then we need to
The
address it.
bond right now is set at 2,500.
Okay,
Your bond upstairs is set at 5,000. Tell me about that Fort Bend case. Is it old? Is it new?
Let me check, Judge.
I think it's 2023.
Is it? I don't know. I mean, because looks like you got on probation in October of this year. When you're on probation, dude, on felony probation, you have a freaking halo over your head. You know, you got to be as good as you can. You're facing a lot of time in prison. Have you been to prison before?
Sir. No, sir.
It's not a fun place, you know, and I don't know what we need to do to get your attention, man. In life, if you're with a person that brings the worst out in you, then don't be with that person. There's a gajillion and one fish in the sea, but how can a person get you so wrapped around your finger to make you, you know, just go. It's like a cancer. When you have cancer, if you don't cut it out, it kills you. This is killing you.
I can contact Fort Bend, Judge, and get more information.
Well, it doesn't matter. It's neither here nor there. I'll do whatever you want to do. You want to set tomorrow, Monday? What?
I'll watch it today and come back tomorrow if you want.
Yeah, I mean, if you want, surely. Do you have it?
We have the camera, the body cam.
I just shared.
Okay, so
They just shared it.
Yes.
let's roll it to tomorrow. You guys take a look at the video as well. Be prepared, and then we can reconvene tomorrow. For purposes of now, I'll find probable cause, and then we can regroup again tomorrow.
Okay, thank you.
Yeah. Okay. All right, Mrs. Zenon.
Thank you.
See you tomorrow.
See you tomorrow. I'm back on Mr. Zenon from yesterday.
Okay. Morgan, I don't, is this yours? Remember, we're back on Zenon, or?
Probably gonna agree to disagree here. But I would like for you to watch like the 2 minutes of the video that I think.
So Judge, I also, because you had this question yesterday, I called Fort Bend and they confirmed it. The Fort Bend County aggravated assault with a deadly weapon, it's just sealed, and that's why I didn't pop up.
It's just what?
It's sealed at the moment.
Sealed. Is it a new case? Is it an
It
old
was
case?
just filed in November, Judge.
And there it is, the moment that changes everything. On paper, the report described pushing, bracing, resisting, impeding. But on video, we see confusion, repeated searches, and even the officer using the phrase resisting transport, which isn't even the charge offense. That matters, because probable cause must be based on what actually occurred, not what it felt like in the moment. The defense's argument becomes simple. If the alleged interference doesn't clearly appear on video, then how can a court move forward on that specific charge? This is exactly why Bodycam footage has become such a powerful courtroom equalizer. It strips away interpretation. And now the judge has to decide, does the footage match the allegation?
Extremely old, right? I would have think.
So you're gonna extend him for 6 months,
Yeah.
you want a short reset.
Very short reset, like
30
maybe
days.
like 2 weeks, 3 weeks to make sure that he's paying.
Okay, great, 2 weeks, 3 weeks, that's around
how?
holiday. So can I make it like 4 weeks?
Okay. Yeah. Hey, so
Joe,
Joe.
yes,
So what I'd like to do is, I guess, set it every couple weeks to make sure that he's paying into the registry to make sure he's paying. First time he doesn't think.
so.
Oh, what's that?
So, excuse me, Shatoria said that he can't make payments to the registry, he's gonna have to pay it in full, so he's gonna have to,
What?
Joe has to.
So how do they say that he's got 2,200 then, or 2,100?
So he has 2,200 to say, he told him, I have 2,200 in my
Oh,
bank. So
So.
he's gonna bring that to my office on Monday. And then I'll stick that on my IOTA account.
perfect. Then I'm happy to do it that way.
Okay.
If so trust you. If you tell me that he's been paying you,
Yes, sir.
I'm happy.
Okay, sir.
So let's do this. Let's set it to Monday. I want to know that he's paid you that, at least that amount.
Okay.
And then we'll set it every, 2 weeks after that to make sure that he's paying you. And it doesn't have to be much, it could be, 50, 75, $100, but I want to know that he's faithfully paying it off. And then, or we can, calculate or have him tell me what is a reasonable amount every 2 weeks.
Yes, sir.
And then
Parents gonna be waived every 2 weeks?
if he pays,
Okay. Okay.
the first time he fails
I'm not gonna read it. It doesn't matter.
is in,
I mean, it doesn't matter. It's on video. It
So I'll
doesn't
make a
matter.
note,
Okay.
parents required, but note,
correct.
if he
Right.
pays.
On video, guys. Like, I watched it. I'm not crazy. Like, it's on video.
Sorry to keep
Let's
waiting.
talk to Judge about it.
Okay. You're still upset?
Yes, I watched the video and I'm even more upset, Judge.
So Judge, we just want to address some of the questions that defense and you had yesterday. Defense was saying that he felt that interference statute was overbroad. We found case law saying that it's, or vague, that it's unconstitutionally vague. We found case law saying that it's not unconstitutionally vague. It's from DeContal versus State. I've tendered it to defense. Can I approach
Sure,
Judge?
I gotta imagine that if it was unconstitutionally vague, someone would have challenged it and it would have,
Well, maybe I haven't had my case yet.
Okay.
and, I'm happy for you to make new law, always.
Judge, did I hand you DeContal versus State? I did, just,
You can't tell.
yes.
Yeah. Oh, look, it's out of court 8 in Harris County.
That's for this case.
So why are you saying that there's no PC in this case?
Is there a PC for something else? Yes. Is there for the interference with public duties? No. I mean, because it's on video, it didn't happen, Judge. So they get calls for an assault, a disturbance, whatever.
You're telling me the fact that they're saying he goes plank in the car while
He doesn't.
being arrested
He
doesn't
does
happen?
not go plank. It's on video, Judge.
Would they say he uses his, I guess he uses
He's in
his,
handcuffs.
The officer has to place his hand on the chest of the defendant to get the defendant to sit back in the car. He also has to grab his legs and push them back into the car. We also watched the video.
We watched the video and we have a timestamp, Judge.
could it be that okay, so I know that a lot of times when they're putting a defendant into the car, they need help, right? They're unable to do it by themselves, or is he actively resisting getting into the car?
He tried exiting the vehicle, Judge. And
No,
that's
he-
why they had to push him back into it.
He leans forward. He's yelling at his mom, record, call. The third time they have taken him out. This is 3 times. They put him in the car and they take him out so they can search him. The cop is sitting there going, oh, well, search him again. We can search him 20 times. If you feel you need to search him 20 times, search him 20 times for your safety. The cop doesn't even know what he's charging him with. DA hasn't been caught. The cop's sitting there go, we're getting you for resisting transport. Resisting transport. That is what the cop thinks he's taking of it. DA, Officer Singh, it's a 27-minute video. Okay? At no point is the DA's office called to this point. Okay? That happens after. Fine. For an assault, they can argue. I can argue case law. Ford v. State, specific articulable facts of crime may have occurred. Fine. They are there on an assault. Okay? They didn't take an assault. So then they detain him, right? They find that he has the warrant. So, okay, you're taking him in on the warrant. Fine.
Judge, it's
It's
common for officers to conduct an investigation before they call intake. That's not an abnormal
Yeah,
thing.
I mean, that's neither here nor there, but the question is he impeding the arrest or the function of arrest? Because I guess that you guys are basing the interference on the fact that he's not allowing him that, what's his name again?
Xenon, Your Honor.
Mr. Xenon is not allowing the officer to arrest him by putting him in the car.
Respectfully, Judge, the officer doesn't even have to be arresting him. They just have to be looking into any legitimate matter. And then he's interfering with that. And I will say, if he'd already been in the car 3 times, like defense pointed out, I would think he wouldn't need help getting in. So to us, it appears as though he's trying to push out. The officer has to put his hand on his chest to push him back into the car and then take his legs and place them into the car.
He was cooperative the whole time. He's on his mom. If anyone's aggressive, it's the cop from the beginning.
Judge, the
And
cop-
I ask at the court's discretion, watch the video. You only need to watch like 2 minutes, the 13 to 15 minute mark, Your Honor. I mean, that's all you really need to watch on this.
Judge,
Watch or no?
we can watch the video, Judge.
Cue it up. Let's watch. Can you put it on the screen somehow? So we can all watch?
We can just go to the back and watch it. Do you want to hook it up?
No,
I don't,
no.
because he has issues hooking his computer up to the technology. Yeah, it's this one.
Judge, did you want to watch the whole video or did you
No,
want to?
just the relevant portion. I don't need to see the whole thing. No, just that part that's relevant. You know, I guess if you wouldn't just put it right there and just turn it around,
Yeah, just put it
just
up
right
there.
there on the table. Yeah, right there. You said it.
I'm just turning the volume up, Judge, as well.
He talking about don't let him pull up. They talking about I got a warrant out for Fort Bend County for assault. Look, he pushing me. Mama, record me. Mama, look. Mama, look. Record him. Now you're under arrest. I'm under arrest. Yep, you got a new charge, Bobo. Resistant transport. Resistant? I wasn't resistant. You just resisted transport. Yep.
What the hell is that?
Now you got a new charge. Yep.
Come on.
Thank you,
This
Judge.
officer's not working intake, Judge.
Really? That's it?
That's it, Your Honor.
That's the relevant portion that defense is.
Oh, come on.
The officer is investigating a legitimate.
I know, but no. All right, I'm
Do
with
you
you.
see why I'm so upset, Your Honor?
All right.
Okay. Thank you, Your Honor.
You can refile this as resisting.
Yeah, look, yeah, I mean, you're not gonna hurt our feelings. You need to do what you need to do. Perhaps it was the wrong one, but yeah. Was it resisting?
Nope.
My name is Bennett and I ain't in it. But no PC.
Thank you, Your Honor.
Hey,
Judge, real quick,
I changed it. Melissa, yeah.
do I need to do anything? Like, I don't know.
There's
If
nothing-
well, I wanted to see if, are they filing a dismissal or no, they're not?
You didn't ask them. I
Because
mean,
then,
ultimately, they don't have to, right? They can take it to a grand
well, then I
jury.
stay on it. That's why I'm kind of trying to figure that out.
As far as us,
I'll ask them.
I lose jurisdiction, right? So there's nothing that I can do.
Right, but my question is, but it's not gonna, it doesn't matter. But if Fort Bend's gonna pick him up, right?
Ben
It has 10 days now, right?
No, let me see. Hold on. So he's on probation for the case
But the
upstairs.
motion's been filed up there.
Let's see. Morgan, do you know what has happened with Xenon upstairs? Have they filed the motion? Are
They
they?
haven't filed it yet. I talked to the felony prosecutor. He said their court's been in trial all week, so they haven't gotten a chance. They haven't really looked at it. I think he said he was planning on filing a motion for Judge.
He got arrested on,
Are y'all dismissing this right now? Or?
She wants to take it to grand jury.
so he got arrested on the 3rd, is that right?
For this case,
Correct. Because once we get him, if there's a hold out of Fort Bend County, they have 10 days from the date of the arrest. Come get him. If they don't come get him, I give a PR bond on the 11th day. Unless I know, and Fort Bend has told me that they're going to, and they've told me they're going to come pick him up. That's the only time I'll hold him an extra day.
So does he need to be appointed a fugitive attorney?
No.
Because it's low.
It's only for
Texas, so-
out-of-state cases. So look, there is a hold out of Fort Bend County. So he's basically bond denied on that case. He cannot get out for any reason. because that.
Because of that, right? This isn't holding him,
So,
though,
On
regardless.
the 11th day, if they've not made travel arrangements to come get him, I'm gonna release him and I'll give him a car bond. So your guys up there have basically another 7 days before.
I'll let him know, Judge.
And so if they refile it, am I still attached is my other question. Do you even know the answer to that?
I think that your duty now ends as the lawyer
Okay.
unless, are you planning on dismissing it or are you gonna keep it?
They say they're going to refile as a resistant.
We still need to know though, what you want to do with this case. Like if you're going to keep it, because if you do, I have to reset it for some period of time.
Check with Chief specifically, Judge, and I'll let you know.
Yeah, check on that because that's gonna depend on my next question.
Regardless, he's in there at least for another week.
Okay, well, real quick, because if I was going to remain attached, then I'm going to ask for a speedy trial.
Yeah, but remember, I got to give
I'm
them,
still attached.
but I got to give them at least 30 days.
Then I'm just going to do the whole PC thing with you again, depending on what the refile is. See what I'm saying? So if they're going to refile, if it's,
It sounded, you agreed to the resisting too, so.
I can agree to the resisting.
No, I'm kidding. But I don't know. Let's see what they say.
I mean, it's not a resisting either.
I don't know, but prior to that, was there with the resisting? The resisting is not there in the car. The resisting was beforehand. I don't know. I mean, as far
I
as I
can show you that as well if I have that.
case is never going to go away.
Just
Okay.
dismiss it for now, just subject to refile.
Okay.
Okay,
Yeah.
cool, thanks. All right, thank you.
So here's where this stands. The judge finds no probable cause for interference with public duties based on the video evidence. That charge is dismissed, at least for now, subject to refile. But the defendant situation is far from over. There's still a Fort Bend County hold. There's still an aggravated assault warrant. And prosecutors are already discussing refiling under a different theory, possibly resisting. What this case really highlights is the difference between allegation and proof, and how critical video evidence can be in modern criminal proceedings. It also shows how low the probable cause standard is, and yet, even that low bar wasn't met for this specific charge. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.